All right, viewers, in midst of all of this, both the petitioners and the government supporters are claiming that this is a win-win situation for them. So who really has the upper hand? And once again, before we get into this debate, to make it clear, this was just an interim order, viewers, that the top court of the country has passed while it continues to hear the case. I want to cut across this evening to Aman Sinha, Senior Advocate, Supreme Court, Sanjay Hegde, Senior Advocate, Supreme Court. Sanjay Hegde, would you want to go first on what is your opinion in the legal interpretation of what the top court said today?
No, the legal interpretation is that notwithstanding a presumption of constitutionality, the top court has found certain provisions which it prima facie says that please put them on hold till we examine the matter fully. Now, just to explain, any act made by Parliament is presumed to be constitutional. You can challenge it in a court. The court will start with the initial presumption that, look, if Parliament has done it, they will have the powers. It may not necessarily infringe on fundamental rights. So the petitioners have to make out a case for an interim order of stay. So the fact that certain provisions have been found prima facie, at least, to possibly lack competence or something of that kind, shows that the Supreme Court believes that there is material in the objections which the petitioners have raised.
Okay. Aman Sinha, would you want to weigh in on how are you going to legally interpret what the top court says? Because, there is a point that Sanjay Hegde is making that prima facie, the court has found that some of the provisions are deeply problematic and those have been stayed. Once, of course, the court hears the case.
Preeti, first of all, what court has said categorically is that there was a prayer to stay the provisions of the entire statute. That prayer has been rejected, and the Supreme Court has very categorically stated that no case for blanket stay of this sort has been made out, and in fact any case for such blanket stay of the entire act has been rejected. This is the foremost point. Secondly, prima facie, as you very correctly pointed out, Preeti, this is an interim order, but even by a prima facie examination, it seems that the legislative competence of the Parliament has also been exceeded and approved by the Supreme Court. Otherwise, it could have been rejected on the first look itself. Thereafter, whatever other balancing measures that the court has adopted, it is only to they are mostly procedural rather than substantive. For instance, as you were saying that the provision of 5 years practicing Islam, that particular provision has been stayed because of paucity of exact rules which would determine when a person has adopted the religion of Islam, etc. So therefore, most of the provisions or stays which have been given on certain provisions of the Waqf Act, they are mostly procedural in nature and not substantive per se. And the broader substantive assertion or what emerges from the court's order is that there is no blanket stay as was sought by the petitioners in this case.
Sanjay Hegde, would you see that? Because the government, in its judgment is looking at this as a win because there was no outright rejection as elucidated by Mr. Aman Sinha?
Well, on a lighter note, Preeti, Professor Mark Galanter of the University of Wisconsin once said that in a court, its idea of justice sometimes is that when two people are fighting over a 100-rupee note, to tear it into two and give one half to each person. So if both parties are equally satisfied or equally dissatisfied, the court often it's often believed that the court has done a careful balancing act. Here, the court specifically uses the word that while the prayer for stay of impugned act is rejected, however, while doing so, in order to protect the interest of all parties and to balance equities during the pendency of this batch of matters, we issue the following directions. So what the court says is that, look, we normally don't stay statutes and we can't just blanket stay everything. Therefore, let us protect the status quo. You say that there are no rules to determine how exactly somebody has been practicing Islam from what period of time, whether it's right, wrong, and all that. We'll see how it works out. The proof of the pudding will lie in the eating later on. For the moment, we are staying some of the obviously problematic provisions. There were provisions which sort of may have ensured that on the Waqf boards, the majority could possibly be non-Muslims. The court has Muslim members. The CEO of the Waqf board will, unless there are extreme circumstances, normally have to be a Muslim, and so on and so forth. The court has done a very careful balancing act. I think it's not a question of who won, who lost currently. What has happened is that an effort to run roughshod has been shown some breaks currently.
Aman Sinha, because there's something in what Sanjay Hegde is saying, because the sheer fact, what looks like a really balanced judgment, which keeps both parties happy, because very rarely do you see both the petitioners and supporters of the government and the amendment coming out and saying, the court has spoken for us today. And it's happened. So interimly, once, of course, the matter has to be heard. So we need to look at how the case proceeds. But interimly, at least both sides are seemingly happy.
Preeti, that does happen sometimes with interim orders, and because each and every issue still is subject matter of the final adjudication by the Supreme Court. But at an interim stage, I can tell you, para 209 of the judgment, I have it in front of me, and it says that in totality of circumstances, we do not find that any case is made out to stay the provisions of the entire statute. The prayer for stay of the impugned act is therefore rejected. Now, there are some of the provisions, as Sanjay was also saying, which have been, for instance, so that, possession is maintained over properties where people are in possession till the adjudication of the disputes. So therefore, some protection has been provided till the final adjudication. Similarly, no third party rights could be created. So this is a usual status quo order sometimes when it is given because, when an issue of this nature comes before court takes a balancing view when the adjudication is going to take some time. But my point is, Preeti, that most of these measures which have been deployed by the court or stay wherever of whichever provisions have been given, those are the provisions where there is some procedural or technical lacunae due to which the stay is given, rather than, saying that it anywhere militates with constitutional provisions or is unconstitutional. In fact, on the contrary, Preeti, the 3-4 provisions which have been stayed, apart from that, large number of other sections were also examined. In fact, all the sections, wherever the petitioners argued that there is a case for stay here, all those sections were examined in detail. They have been dealt with in detail, and the prayer for interim stay with respect to those sections, whether it is work by user, whether it is applicability of Limitation Act, etc., they were all prima facie rejected by the court.
Sanjay Hegde, the sheer fact that A, there was no outright rejection, B, some of the very contentious provisions of the amendment have not been stayed. Do you think it's paving the way, what many say, for the Uniform Civil Code?
No, the Uniform Civil Code is a different matter altogether. That is largely with regard to matters of marriage, divorce, succession. If your question is, does this interim order foreshadow what the court thinks in terms of charitable bequests or bequests which will go on for eternity, like in the case of a waqf? I should not make any such presumption, because, as Aman said, a lot of interim orders are essentially to protect what the status quo currently is. till the matters can be finally determined. You see, there were many provisions which allowed the collector to simply decide that something was a Waqf property or not. The court has said, no, 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 you can't do it. You can't do that would violate the separation of powers. Claims would have to be decided by independent bodies, including the Waqf tribunals. And so I would think that this matter will have further ramifications when it is finally heard. For the moment, suffice it to say, the expansive expansion of the law that the administration has wanted has been curtailed by the courts. And there is plenty in this rather detailed interim order which will keep executive overreach under strict control.
And Aman Sinha, wasn't that one of the primary motives in any case? Yes, you have some who say that there is no outright rejection. Some of the contentious, points have not been stayed. But when it comes down to executive overreach, that in itself would be stemmed by the interim order.
No, Preeti, in fact, there is no executive overreach. And if there had been an executive overreach, it should have been recorded somewhere in the judgment. Judgment, in fact, goes on to reject the prayer of stay which was made by the petitioners. Therefore, there is no case of executive overreach. As I was telling you, because all the issues are still subject matter of final adjudication and determination before the Supreme Court, in order to balance certain rights of contesting parties, they have given some certain, status quo under certain provisions. However, most of the provisions, they have declined to give any stay. Preeti, you would note and remember that the entire act and in fact all the provisions were challenged. And in fact, later on, court went on to say that we will examine all the contentions which are given by the petitioners. And most of the provisions have withstood this test at a prima facie stage. And I would say that it very clearly indicates that A, there was no case of blanket stay, B, that the parliament had the legislative competence to legislate on this issue, and C, that it validates the Act's objectives of transparency, efficiency, and prevention of misuse.
Sanjay Hegde, would you want to weigh in on this?
Muslim
because I need to quickly get into a news break.
On these Waqf properties.
Right.
Well, the law in effect has been defanged. That is where I would read the order. The most obnoxious portions of the law, the ones which were heavily contested, particularly allowing the collector to just declare something to be government property and forgetting it to be a Waqf, all that has been stayed. The longer battle remains ahead. So I would not want to get into further premature adjudication at this point.
All right. That's, final point, Aman Sinha, if you want to come in on this, because the sheer point of the amendment, the law being defanged, especially in at least one of the most contentious issues, which Sanjay Hegde is speaking of, that in effect means a stemming of executive overreach.
No, Preeti, what I would say that after a prima facie examination, the Supreme Court has appears to have upheld the constitutional validity at a prima facie stage on a prima facie view of the matter. Not only that, on a prima facie view of the matter, the court has also rejected the large number of stay prayers which were there with all the provisions of this Amendment Act, and only in a few provisions wherever there were procedural lacunae or omissions, or where rules would not have been framed as of now, the court has stepped in and said that all right, you frame the rules, but this does not militate with any constitutional provisions, and has withstood the legal scrutiny at a prima facie stage. It in fact goes on to validate the government's intent, effort and objective of making the Waqfs more transparent, more accountable, and in consonance with law, which would prevent any misuse of the Waqf properties by vested interest groups.
All right, I appreciate both you gentlemen for joining me. Thank you there. Once again, viewers, this is just an interim order.
Thank you.
The case continues to be heard, and we're going to keep a keen eye on all developments. While there's one section which seems to suggest that the top court has defanged the law or the amendment, there is one which says that, no, there's no outright rejection. This actually upholds the parliament and the law.